Hi, thank you for subscribing to this channel. This is Batok Petola. My name is Mujola Oluwa. Today we want to talk about constructive dismissal. It's a very important topic and it's in the field of labor and employment law. I've told you that we'll talk about labor and employment law more on the channel. We've talked about probationary period and we've talked about covenants and restraint of trade. But today we want to talk about constructive dismissal. The easiest way to understand this is to talk about constructive and actual notice, and these are also concepts in law that we will talk about much later in other videos, but let me explain them briefly. Actual notice means that you were actually notified. For instance, you were served a letter or you were served a court process, notifying you of a state of things, the existing state of things. Now that's actual notice. You were notified directly. Now, constructive notice means that you were not notified directly, but the circumstances are safe enough for one to assume that you have understanding or notice of what is going on. For instance, if you enter into a courtroom now, you see the judge sitting, you see a lawyer standing, addressing the court and all of that. You should have constructive understanding or notice that a trial is going on. That's just a very basic example. But you would have actual notice if you were given a court process asking you to come to court because a trial is going to go on that day. But constructively, seeing what is going on in court, you are deemed to have been put on notice that something is going on, and as such you should conduct yourself as proper. So that's how to understand actual and constructive. Now let's take it to constructive dismissal. So we could have actual dismissal where your employer fires you directly by issuing you a sack letter, for instance, or a dismissal letter. But constructive dismissal would be that your employer has not fired you, but they have made the working conditions so unbearable, so toxic, so unreasonable that you're forced to resign. So now the resignation is coming from you, but it is a consequence of their action and of how they have conducted themselves towards you in the workplace. So that is constructive dismissal. This would mean, in basic terms, that you were forced to leave your job against your will because of the conduct of your employer. So there are key terms. You were forced to leave against your will, not that you wanted to leave before. And it is as a result of the conduct of your employer. That is constructive dismissal. Now, there are some things you should look out for you to be able to determine if there's constructive dismissal, if you have a case or not. Because it's not in every case that you leave because of some inconveniences from your employer or your workplace that you would have a case, a solid or a valid case of constructive dismissal. There are 4 things to look out for. The first is that your employer's conduct was actually in breach of the terms of contract of employment. Now, if you have a contract of employment that says that your work is 8 to 4, for instance, and your employer keeps expecting you or mandating you to work till 7 till 10 p.m. every day, they have already breached the terms of the contract. So there's a breach by your employer. That's 1. 2 is that it is a serious breach. So it's not just any slight inconvenience. For instance, if they're asking the entire workforce to stay and work, for say 30 minutes extra, once a week, because of certain circumstances that require it, it might not be serious enough for you to claim constructive dismissal or for you to even leave the workplace. Also, if it doesn't even affect you alone directly. But say that they keep saying you have to work till 10 before you can be paid, and now they're tying your salary to work hours that were not part of the contract that you signed with them, then we can say that it's serious enough to warrant constructive dismissal. But that's not the only thing the court will look at. This is just one of the legs. Another thing the court will look at is the unreasonableness of the circumstances. For instance, if you have been employed as a lawyer, and your employer keeps sending you to the market to buy pepper for them and onions, to take their children to school, to do domestic chores in their own house, this is not the contract you signed with them. It is very unreasonable to make such demands of a lawyer and to tie their being paid or remunerated, to it. So that would be very, very unreasonable. The test of unreasonableness in this case is that of a reasonable man, the man on the Clapham omnibus, what would he think? How would he react, if this kind of scenario were painted to him, or if he found himself in this circumstance? So that's how to determine how reasonable or unreasonable the circumstances are for you to claim constructive dismissal or for you to leave. And the last thing is the intent of your employer. The court will try to look at it. Did your employer intend to continue to breach the contract, or was it just a mistake, maybe an overstepping, a one-time overstepping, or an inadvertence, that was not perpetual in nature? So the court will look at it. Did they have the intention of continuing the breach? So if these four things are present, you may have a solid case of constructive dismissal. Now, constructive dismissal manifests itself in different ways. Let's give a few instances. Demotion or stagnancy at work. Others have been promoted over you and you have remained on the same spot. No cogent reason has been given. You're doing your work, you're turning in, you're fulfilling your KPI, you're turning in your deliverables, you're doing what you're supposed to do. They just refuse to promote you. Unexplained, unreasonable stagnancy, stunted career growth, foisted down your throat by your employer, demotion. It could constitute constructive dismissal. Another could be suspension for an indefinite period without pay. If you've been suspended, you can no longer carry out your responsibility according to your job description, and probably without pay for an indefinite period. So you're wondering, am I still in their employment? Am I no longer in their employment? It could constitute constructive dismissal. We've talked about forceful change of job description, making you work outside the scope of your contract of employment or beyond the scope as to time, as to activities to be done, as to deliverables, that could also constitute constructive dismissal. It could even be discrimination at work. It could be racial discrimination. It could be gender discrimination. These things could constitute constructive dismissal. Also abuse, physical abuse, verbal abuse, mental abuse, financial abuse, even sexual abuse at the workplace. These things can constitute constructive dismissal. Also, allowing other workers bully or harass you, or being harassed or bullied by your employer, it could also constitute constructive dismissal. Let me read what the court said in Ebere, Ukoji, and Standard Alliance Life Assurance Company Limited. The court said constructive dismissal occurs when an employee resigns because his or her employer's behavior has become intolerable, heinous, or made life difficult that the employee has no choice but to resign. Now you have no choice. It must be established and you must resign. Another thing that's very important is your resignation. If you stay and continue to work in the circumstances that are intolerable for you or heinous, in this instance, you may not have a case of constructive dismissal because your employer will make a defense that you never left, you continue to work. For constructive dismissal to take place, you must have left the employer's employment for constructive dismissal to hold for you. Very important. Else your employer will just claim condonation. You condoned their act. You did not speak up, you did not leave, you did not protest it by leaving. You continue to earn your pay, you continue to do the work, to do the things they asked you, you continue to do the things that you found unreasonable. You continue to endure, so to speak. So you cannot claim constructive dismissal. And the rationale would be that you cannot have your cake and eat it. However, if you have been able to ascertain that the workplace is so intolerable for you and you need to leave, before you head to court, there may be a few things that you can do. After leaving, or when you're planning to leave, you could approach any mechanism set up by your employer or your workplace to resolve things like that. Let them look into it and maybe prefer a solution. If none is forthcoming, then you can try other alternative dispute resolution methods such as mediation. You could go to a mediation house, or you could go to any other form of settlement, involve any settlement method that you think might help you and your employer come to agreeable terms. But if not, you can head to court. Don't forget what we've talked about in this video. Constructive dismissal means that your employer is literally choking you out of work. and as such you decided to leave. Now, after you have left, you can approach whatever dispute resolution body or mechanism set up by your employer to look into cases like that towards the end of getting redress. If not, you can go to an outside dispute resolution body, and if not, you can go to court. What this does for you is that it gives you, a string of receipts to present in court that you actually tried to settle amicably and to get your employer to do right by you before coming to court. And if you go to court and you have all these grounds and instances and features that we've looked at in your favor, you should definitely get redress. So that's what I want to talk to you about in this video. Don't forget to like the video and leave comments in the comment section. I will see you in my very next video. Don't forget to subscribe to those. I recall that I had a client once, and we had to put together a constructive dismissal case, a UK client now. So here's what happened. She was being passed over by a direct supervisor at work. She was qualified, she was an engineer, and she was a top shot. But they were giving her work, what she used to do for the company, to other people in the company to do for them. They were talking with external contractors, which she used to talk to on the company's behalf, such that the company was even losing money and getting bad results as a result. But just because they were racially discriminating against her, they did not just want to keep her in the loop. She was being left out of important conversations that related to her work, being left out of meetings, email conversations, threads, and all of that. So we were able to pull together a constructive dismissal claim. Of course, she explored ACAS, which is the dispute resolution method set up by the UK government for cases like that, before she went before a tribunal. So when I say that you should explore other dispute resolution methods, it may not be for your with your employer, because if you have already left, they may not want to have anything to do with you. But if there's an entity like the ACAS system in your country, I'm not certain there's something like that in Nigeria, but there are dispute resolution houses. You could go to a mediation house, go to the multi-door courthouse, so you could explore that before you head to the court for a constructive dismissal suit.